Good morning, councils. You may be seated. Thank you for being patient with us as we're trying to address a few technical issues.
And your microphone.
The clerk, please call the case.
With the Supreme Court case number CVA24-002, John Ryan petitioner appellee, the Edward M. Birn, in his official and individual capacity as Director of the Department of Administration, respondent appellant. Attorney for petitioner appellee is Attorney Robert J. Huseman. Attorney for respondent appellant is Attorney Nathan M. Tennyson. All members consist of Chief Justice Robert J. Torres, Associate Justice Edward Carnero, Associate Justice Catherine O'Neill. Attorney Tennyson reserves 10 minutes.
You may proceed, Mr. Tennyson. Unusual seeing you on that side of the lectern.
It's a nice change of perspective. Good morning, Chief Justice Torres. May it please the court. We're here today on an appeal from Director Birn. A limited issue. We're not here to dispute the trial court's determination of disclosure of whistleblower documents under the Sunshine Act. What we're seeking clarification on is how the statutory fine should be applied as to directors. I believe a lot of the issues have really been teased out in the briefing. There's two main issues I'd like to discuss today. One is just the general standard for these kinds of fines in other jurisdictions. And second is if this court would be interested in looking at adopting those kinds of provisions, how they would apply in the trial court here and in cases in general. So generally, this does arise under the Sunshine Act or FOIA. In some jurisdictions, it's a FOIA. Some jurisdictions, it's a Sunshine Act. There's been a big prevalence in adopting these standards, making public information or public documents open to the public. They can come request and get disclosure within a timely manner. And I think everyone would say that's a good thing. Generally, when disclosure is not had timely after a request, there are some mechanics to get enforcement, to get disclosure, to make the party, the petitioner, whole. That's an award of a reasonable attorney's fees and costs for the prevailing party. And there are awards of fines. Almost every jurisdiction has fines. Generally, the fines in most jurisdictions are awarded against the agency directly, and then the agency pays those. The agency pays the attorney's fees. Similarly, in Guam, agency pays the attorney's fees. There are a few jurisdictions where the director or the responsible party can be fined personally for lack of compliance. We cited those in our opening brief. Guam is one, Minnesota is one, Wisconsin and Michigan are others. And in the other jurisdictions, Guam's unique because they use the justification standard. Other jurisdictions use either a willful violation of the FOIA or the Sunshine Act, and two others, Wisconsin and Michigan, use arbitrary or capricious denial. And when the courts have looked at those, part of that determination is they look at justification. You know, justification, I think, is the key word that ties all these together. Excuse me, together. Now, when Guam adopted its Sunshine Act, they used justification in two statutes. One is disclosure of the documents justified? If it is, the court shall order their release or shall order the director to release them. Two, if disclosure is not justified, the court shall enter a fine of $1,000 personally against the non-complying director. Now, that term justification isn't defined in the Sunshine Act. I went to Black's Law Dictionary for some guidance, and Black's Law Dictionary defines it as two propositions in that. One is a lawful or sufficient reasons for one's acts or omissions, or two, any fact that prevents an act from being wrongful. And our position here is really that the trial court is capable of determining that under law, disclosure was required. And I think the issues brought up on the briefs are a good example of this. There's a lot of technicalities involved here about when the Whistleblower Act was adopted. When these initial whistleblower documents were created back in 2008 or 9, the Whistleblower Act was adopted in 2018. Even in the trial court, they cited more to the IRC provisions of this in the whistleblower documents. That stuff was adopted in 2010 or shortly thereafter. So I think the real issue there is if we're looking at a director who, in the trial court, I think one of the big issues we have is, on review, it looks like the trial court just determined wasn't justified, awarded fines. There wasn't really a creation of a record as to Director Birn giving testimony, saying, making any statements. Everything was done through counsel. The answer is rather plain.
If Director Birn, could he have just simply complied by claiming the exemption that he wanted and then redacting the documents and submitting them? I mean,
Yes.
couldn't he have done that? Or are you suggesting that even redaction would not comply with 37104's broad exemption saying anything dealing with a whistleblower can't be disclosed?
Yes, so that's a good question that was raised in trial court by the petitioner, and I think that's a good, strong, cogent argument. That's our weak spot on this. If we look at the record, Director Birn he asked for more clarification. What's being sought? Clarification was given, and then nothing further was provided. No response, no documents, no redaction. They went up to the trial court on the OSC and just said, here's the documents, and they did set forth their concerns. In regards to would that have met compliance, I believe the big issues raised on that issue at the trial court were that one is, are you just redacting the name? And even if you're permitting the numbers, now, I think the issue is with the numbers argument saying, well, if we disclose it, you can determine the amount of taxes. There's an exemption for that under the Sunshine Act. It says that those numbers shall be open to the public. Where I think it begins to hinge on your question, Chief Justice, is it's less the issue of the compliance and more the issue of, was there a confusion or good faith basis for confusion of such that the director or DOA looked at it. And this part's difficult for me because there's no record for me to go back, look at and see, well, why did you do that? Why did you do it in this manner? To say,
but isn't that the issue in terms of determining whether or not Director Birn was justified? And he argues that this whole area as to what is exempt from disclosure is difficult to navigate, and so the tension that you may have just brought out in reference to under 10108D, numbers can't be held back, that they're subject to disclosure. But under 37104, which includes the reference to 37103, that any information regarding awards to whistleblowers as a result of informing regarding those who are not upfront, or that those who may have cheated the government in their taxes, that's fully exempt. So while the issue here may not be, which is the correct interpretation, does that suggest that there is a basis in which Director Birn may have withheld these documents?
To that, I would agree. If we look at the trial court, was there a better way to navigate it in hindsight? Going from that point, the names could have been redacted, the numbers could have been left in place.
But even you just read 37104 and it's reference to 37103, and when you go back and read 37103, it exempts from disclosure awards made to whistleblowers altogether. And so was there even any need for any redaction?
Oh, I see what you're saying. As a matter of technicality, as we were looking at it, people were asking me, can we challenge the trial court's determination in general? And my leaning to was not, one, in hindsight, after Petitioner Ryan brought up the timing of the statutes, and were these really whistleblower claims brought under that statute, I think we would be looking at that analysis of did those documents come in the purview of that statute when they were made before? I think there's no question that they were whistleblower reports. I don't know if they fell within the purview of the statute.
But that's not what was being requested by Mr. Ryan. At least it's been made clear on appeal that he is not requesting for information. He was requesting awards numbers so that he can have some basis in which he is pursuing a claim or making a claim of an entitlement as a result of his efforts. And so it really, it's not the information that we're at issue, is at issue here.
Yes.
And while you're thinking about responses, I mean, the whole issue that I'm having here in my mind in reference to Director Birn is just the lack of any response within the 2-week period from the time that he responded. There was a response until such time as the complaint was filed in this case.
And that's an issue I mean, as indicated earlier, that's, I think, our hardest issue is why wasn't there a response? Why wasn't there a statement of there's an exemption applicable? And then you go from there. There was just nothing. And I look at the trial court record and there's not a lot for me to glean from that. And that kind of segues into the second issue I wanted to address, which was what would we be looking at in terms of making a determination like this? And to that extent, I think I put the cart before the horse when we did our opening brief, and I said, "Oh, just fine that he was justified, that there's no problem here." I think the proper proceeding is you would have an evidentiary hearing on this in the trial court, and the trial court would ask Director Birn, why did you, not issue that second response? What was the method? What was the analysis? What was the basis for that? And to look at the reasonings provided for that. There could be bad faith reasonings behind that. There could be not bad faith reasonings behind that without having access to his mind and being able to ask him, why didn't you do that? It makes the determination a little more difficult. I think my primary issue with the proceedings in the trial court relative to the justification term is just there was the OSC hearing on the disclosure, and then from that the trial court went immediately into disclosure of the documents, which is fine, and then said, well, there's no justification as to Birn for the fine, and therefore I'm going to fine him under the statute, when there wasn't really a good record to, and under the statute we can say, justified is the same under either statute. If you're justified for disclosure, you're justified for the fine. But I think a better way of doing it would be having an evidentiary hearing as to the justification for the rationale and asking those kinds of, in this case, I think, hard question. Why didn't you put that forth in your response? Why did you wait until after the lawsuit to raise that issue on a legal basis? There could be good reason, there could be bad reason for that. And that's something the trial court would look at and say, well, the mere fact that you didn't respond, you may have had a decent legal basis or a confusion of law on that fact, but the reason you provided for not responding in time, I don't find to be persuasive. Or trial court could say maybe there is something that he would have that would be persuasive. I'm not sure on that. But I think where the real kind of pivot point here is, we have a lot of avowals from counsel as to why it was done. Counsel comes in after the fact and tries to explain it, but we haven't heard from Director Birn as to the basis. And entirely possible, Birn is heard from in the trial court. Let's say they did have an evidentiary hearing. Director Birn testifies, provides information. Trial court hears that and says, I've considered all this. I still find bad faith. I'm still going to enter the fine. At that point, I think we would have that process in place that the trial court does have discretion to do that. Even below petitioner indicated, it is up to the trial court. But when I look at the order, I just don't see, if there was a finding in there saying malicious, bad faith, here's a factual basis, I would go with that and say, okay, defer to the trial court that's within their discretion, short of finding an abuse of discretion with some kind of fact in the record, which also we can't cite to. And really, I think that's why we're here, is just, this process of teasing it out. I mean, alternatively, this court could determine, well, justified is the same in both cases. And, if you're wrong as a matter of law, you get fined, strict liability. That's the standard we want. But I do think that the term justified has a little more liability than that. As to the disclosure itself, justified as a matter of law, I think that's very clear cut. Justified rationale, we do have some legal.
Well, in my mind, justified is this: there's some reasonable basis for Director Birn to have withheld the case or is undecided in reference to how to respond. Is there a reasonable basis? And I think that's the issue
Yes.
in relation to what's in front of us.
And
part of the issue.
I agree that could have been better teased out below, had Director Birn given that second response and said, well, I believe this is a whistleblower issue. It's not exempt. Or even, I believe parts of this are whistleblower protected. I'm going to redact, and here's what we're redacting. And if you disagree, you have your remedy through seeking a Sunshine Act action through the Superior Court. And then the trial court can determine on that basis.
The fact that he didn't respond at all within those 2 weeks, I mean, can this court still find if there's a statutory section that may create some basis in which to withhold the documents? Can this court still find that Director Birn was justified, even if there was no response given within that 2-week period of time?
I believe you could go two ways on that. One is yes, one is no. I'm going to argue yes first for Director Birn's sake. When we look at that issue, I believe it becomes an issue for the trial court to determine what was the basis for not complying. Now, the statute is strict in its compliance requirements, but there could have been some mitigating factor or other that Director Birn would be able to provide as to why it wasn't timely. I'm just guessing, I'm not saying this is the state of things, but, things get lost, things don't get received. There's other stuff going on. There could be some mitigating factor. Now, as to a basis for why the court could look at that noncompliance and say, well, that itself was a bad faith act. You could hold that under that statute, it's strict compliance, and the mere fact that you didn't comply in time. At that point, I think you'd say, even if you had given a response and said, well, hey, this is exempt under this provision, that's a response within the deadline under the statute. Court could look at it and say, well, strict compliance, you didn't provide any response, and automatically we're holding that as bad faith because you didn't provide an explanation. I think some of the, not necessarily risk there, but the general issue I'd be looking at in that interpretation is, what was the basis? Would the trial court be able to hear that basis and then have discretion to look at that noncompliance as a factor of bad faith? There are factors under failure to comply that would be bad faith. There might be some that would not be bad faith. If it was just, oh, I didn't think it was very important, and I, forget it, we're not going to answer that. Bad faith. There's lots of stuff going on. It got lost in the shuffle. I directed one of my lower staff to issue a response, and my lower staff didn't do it, and I was unawares until after I got served with the lawsuit. I don't know if that happened or not, but I could see that fact pattern being in there. And without knowing, without being able to talk to Director Birn and have him provide that information, I think that's really the factoring point in there is, do we want to have strict compliance on this kind of a thing, or do we want to have the trial court to have a little bit of discretion to look at the factors and to provide some level of equity? Because at the end of the day, petitioner still brings that Sunshine Act, still has a strong basis, therefore prevails, gets their attorney's fees, gets their costs, gets their disclosure. Trial court looks at it then thereafter If there's bad faith, $1,000 fine goes to the Guam Ethics Fund. Who's the, and that's the other part is the Guam Ethics Fund gets the fine. And I believe that's really a public policy determination to further ethics training, to further the Guam Ethics Committee's endeavors to make sure that people know what they're doing, make sure they're properly informed, they're doing seminars, giving training sessions. So we could have a public officer who has gone to all those sessions, done their training, making a good faith effort, makes a mistake on a technical issue of law, even though they were confused in good faith. Should they have to pay $1,000 out of their pocket to that ethics fund?
The judge didn't really evaluate the failure to disclose the requested information not being justified, right? It was just
no, nothing I saw on the record. The OSC was very limited in regards to the issues brought up. It was basically counsel discussing the issue, the trial court asking questions, the documents being provided, and then it was ended. And then the trial court entered their determination, finding disclosure documents proper, and also finding for the fine, and just said, it wasn't justified. I'm issuing the fine. So I think there is some leeway here to assist the trial court with providing them with that discretion, even if they find the same thing here, have an evidentiary hearing, find, there was no good faith. I'm going to uphold that fine. With that, I reserve 10 minutes.
you did, and you're at 9:47. So
thank you.
Mr. Houston.
Good morning, Your Honors. May it please the court. This is a Sunshine Act case, and it's an important case because it allows the people of Guam to track how the government.
Bring the microphone towards you.
Sorry, Your Honor. Thank you. This is an important case. It allows the people of Guam to track how the government of Guam spends their money. This appeal requires Mr. Ryan to defend his judgment, and he's asking the court to do that. To affirm the judgment will send a message to the bureaucracy that they have to follow the Sunshine Act and have to respect its dictates. With my time today, I'd like to discuss 3 issues. The first is, under this court's precedent and the facts that are presented to the court, there was no choice. Director Birn did not act reasonably withholding these documents. Second is the fact that neither the IRS regulations that are cited nor the Guam Whistleblower Act provide a justification for withholding these documents. And finally, Director Birn violated the law as it is written, and he should be made to pay a fine to the Government Ethics Fund. Before I get into those 3 points, however, I do want to make a small point about some of the arguments that have been made about the order to show cause and the record in this case. So an order to show cause it was Director Birn's opportunity to explain his actions and why he failed to turn over documents. And anything that is, perhaps missing, or if the record is thin, is due solely to Director Birn and Director Birn's attorneys failing to show cause. Any problem in the record, anything that's lacking, anything the court has any question of, falls squarely on the director and his attorney for failing to put that into the record, to provide those reasons why they failed to follow the law.
But didn't he cite the Whistleblower Act when he did that? I thought in one of his at least in response to the OSC, stating that the records pertain to actions with respect to historical payments made to whistleblowers.
Yes, Your Honor, and I think there's an error in my paper where I say that that argument was waived. I don't believe it is. I think he did waive that he put that in a sentence in the paper response. I believe that's correct. He did. But at the actual hearing, when asked to provide specific exemptions or whether the court should ferret it out, the Director Birn said, well, we just want to give you all the documents and let you see. Well, that's not the court's job, Your Honor. That is Director Birn's job under the statute. And as we point out in our briefing, a government agent, a bureaucrat has a duty under the statute and should take that duty seriously. Otherwise, there are some punitive fines involved.
Well, I mean, the government says that phrase is taken sort of out of context about him ferreting it out. I think they cited in, I don't have the specific provisions in front of me, but I think he referenced that there was additional language where they were talking and they didn't mean to suggest that the court had to do it on its own. So he said that, I'm just trying to see that, what they were specifically, he said he was open and candid with the trial court about his concerns on disclosure. You know, it was the trial court who asked whether it should ferret out these positions. And in fact, he said that you said you're not accusing them of trying to block it. And you appeared to leave the issue of whether the $1,000 fine was appropriate to the court's discretion. What you were more interested in was making sure the fees got paid, and they acknowledged that they should pay those fees because you were the prevailing party and got the documents disclosed.
Sure, Your Honor. And so what I would say, I guess, to that question is a couple of things. I think there's two parts in there. One is whether or not they were supposed to ferret it out, and two, I guess my concerns at the hearing. So first, whether the court or whether they were told the court to ferret it out, and this is just a polite dispute I have with the government on this issue from this standpoint. As a former attorney general in a different jurisdiction who's handled open government requests, the point of an open government request, if you're going to withhold documents, is to tell the court exactly what was withheld, why it was withheld, and under what exemption it was held. And that way it gives the court an exact opportunity to look and figure out why you claimed exemptions and what documents you claimed exemptions for. As we point out in our briefing, and as we point out in the at the trial.
Didn't they say to the court that they had been instructed to keep whistleblower documents confidential? That was DOA's. I mean, he cites to the excerpts of record lines 49 lines 2 and 3 that was what their position was.
I think their position at the trial court was that the Department of Revenue and Taxation, who Mr. Ryan is having a running fight with currently about payment of awards, told the Department of Administration to keep its mouth shut, and they obliged. I don't think that is an exemption in the statute. So if what
about the 37104, which seems pretty broad, doesn't it? When you're trying to reconcile that with 10108, because 37104 says any information furnished pursuant to 37103, I mean, shall be exempt.
Right.
I mean, it doesn't even talk about partial exemption and redaction. So, you know, you've got that language in 37104. You've got the language in 101 3D, which talks about redaction. And then you have 101.8, you have B, which talks about the records of investigations or complaints. And then you also have the provision on payments of monies owed in D.
So and I think under an open records request, all those have to be read together. And so to answer your question, I think the 37104 does not cover these documents. So what Mr. Ryan asked for were payment records, and payment records are quintessential Sunshine Act records. The people need to know how the government is spending its money, where that money goes, and how large those payments are. And almost any time the government makes any kind of payment, that is just a public record. It must be disclosed.
But if you read the payment of monies owed to a person, and you make that payments of monies owed to a whistleblower, who is, you know, if you suggest that a whistleblower is a person, do you think that's not exempt then under 104?
No. So what I would say is in this case, the name of the whistleblower might very well be exempt. The monies sent to the whistleblower are in no way exempt.
Yeah, but the deed provision doesn't provide for that, right? The 3104 says money is owed to a person. It makes no distinction of redacting that person's information. I mean, the idea is, I think D is intended to cover information from taxpayers and it doesn't suggest that you have to keep the identity of the taxpayer. Otherwise, it would eviscerate why you would make that disclosure. To me, that's a separate provision than the whistleblower issue.
Sure. And so I guess, under Guam's Sunshine Act, if money is going out, any payment made to a person needs to be, that is a general provision, so it needs to be produced. So if I, Brad Huseman, have a contract to sell widgets to the government of Guam, I, Brad Huseman, my contract and the amounts of money for the widgets need to be produced. If
You think the D provision is broad to include payments of money, not just involving taxes, any money?
Yeah, any money, Your Honor, because all money, basically the government of Guam comes in the form of taxes. It's either a fine, a tax. The government of Guam isn't doesn't have IP, doesn't have a way to raise money aside from its power to tax and to levy. And that's what we're talking about here. And to keep control of the government, to realize this idea of self-government, requires people to know where their money's going, where it's spent. This isn't an independent bureaucracy that gets to do what it wants. And the only way to, or not the only way, but one of the most powerful ways to keep track of how what a bureaucracy is doing is to keep an eye on the funds. And so as a general principle, I'm sorry, go ahead.
No, go ahead. Finish. I didn't mean.
As a general principle, I would say that the 10108D is any amount of money to who it goes to. If there is another more specific exemption, and there could be a fight about this, and later on, this court might want to take that issue up as to do these whistleblower exemptions, do they cover the name? Right.
But Mr. Huseman, isn't the issue not what is the correct interpretation and between the tensions of 10108D and 37104, which incorporates 37103? In my mind, the issue before this court is not what is the correct interpretation of what is subject to be disclosed and what is exempt, but whether or not there's a reasonable basis for a justification that this is an ambiguous area, and that if Mr. Birn decides to withhold the documents because it was just not clear in his mind whether he would be violating 37104, that then there is some reasonable justification for withholding the documents.
And in this case, no, in this case, there is no reasonable justification for withholding these documents, because as we pointed out, if you look at the documents, only one of them has the name of the whistleblower on them. These documents are quintessential Sunshine Act records. They are subpoenas from the federal government to the Department of Administration and the Department of Revenue and Taxation, seeking apparently an investigation into the irregularities of the payment. And the Director Birn has now had two chances to explain why and how he's protecting the name of a whistleblower or the information provided by a whistleblower by withholding subpoenas that were served on his department and on the Department of Revenue and Taxation.
But that's not what you're asking for. You're asking for what are the amounts paid to whistleblowers by Rev and Tax. That is the remedy that your client is requesting in terms of the information. And if there is nothing relevant as to that, what is the issue in terms of withholding the documents that you are not asking for?
Oh, I was asking for those because those documents are picked up in that request. I wasn't just seeking, I was seeking any documents at all relating to the payment of funds. And we received a bunch of documents relating to funds. Now, some of those are the checks. And one of the checks, which is written out to the Department of Revenue and Taxation on the back, has the name of the original whistleblower, I think. It's not even clear because they didn't make a specific objection to any of these things, as the trial court says. So it's not, this is a guess on my part. It isn't a rock solid fact, but I think it's a reasonable guess. And so what we have here is one document on the back has an endorsement, and under the law, if this was an actual concern, then the law requires a redaction and production of that document. So then I would have had a document that indicates a check made payable to Department of Revenue and Taxation, and the back would have been redacted. And then there would have been a letter that says, if this was done correctly, that says, we withheld the name of the whistleblower under this section. And at that point, Mr. Ryan and the court have an idea of what the exemption is, why it wasn't produced. And let me back that up and just say, Mr. Ryan has an idea. He doesn't have to bring a writ at that point. If he doesn't want to bring a writ, he's like, I don't care about the name. I just care.
So you're saying that you wanted documents also that were not responsive to your request?
I think these are responsive to my request.
But what is the information that you're asking for?
I was asking for all information related to payments. Any way that the Department of Revenue and Taxation made an award payment before. Because the reason my client, I don't know if this is terribly germane to this appeal, but the reason my client wanted all of those documents is that for the past 3 years, the Department of Revenue and Taxation and the Office of the Attorney General have been saying, no, you can't get an award to Mr. Ryan, and saying that if they collect money, if they physically collect money that Mr. Ryan made them aware of, that they weren't collecting originally.
But isn't what is exempt from disclosure information regarding payments, but what is not exempt is the amounts paid to and by the taxpayer?
Agreed. So I think, no, I think what is exempt under the current whistleblower law, which these documents, none of the documents that we're talking about were submitted under the whistleblower law, because it predates the whistleblower law, but documents submitted under the whistleblower law by the whistleblower. So if Mr. Ryan goes to the Department of Revenue and Taxation, as he did, and says, these individuals are tax cheats, this is how they're tax cheating, you should do an investigation.
But 37-104 says anything under 103 is exempt, and 103 provides for awards to whistleblowers, right? So it's not only the application, but it seems to deal with the awards itself.
I would say that the award, and again, this wasn't paid out as an award under 37-103, so I don't think that applies.
Why the amounts that were paid in these checks were not paid as awards?
They were paid under GTTC 37-1 something or other. They were paid under the federal income tax. They were not paid under the Guam False Claim and Whistleblower Act. As we point out in our briefing, the Guam False Claim and Whistleblower Act was passed in 2018. But
when the records, I guess, I mean, there's this argument about at the time the records were requested, would they have qualified under a whistleblower protection then? I mean, sure. If you're relying on, I mean, so you're suggesting that all those claims that were paid under the equivalent of the Whistleblower Act under the IRC, that the revenue tax would be mandated to disclose the identity of all of them?
No, I don't believe so, because I believe 10108B exempts complaints. And I think a complaint could be the name of the whistleblower. But
yeah, if you're talking about the amounts that are owed to that person under D, and they paid the award, I mean, it would seem the same rationale would apply, that they should be able to get the information of the payments made to that person. And the other thing that I'm curious about, if we go back, the general right to inspect is not found in 1108, right? That 1108 deals with limitations on the right of inspection.
Agreed.
1103 is really where the right of inspection comes in.
And it is broad, yes.
Yeah.
And so if the court is asking me, does the name of a whistleblower need to be released? I don't know the answer to that. Certainly that isn't really before this court now. That is an interesting question. I believe whistleblowers should be protected. I represent a whistleblower. Mr. Ryan is a whistleblower, but the government of Guam has provided Mr. Ryan no protections whatsoever. So, so I'm sympathetic to this idea that a whistleblower deserves some protection. In this case, I believe the original whistleblower is deceased. So, and it was already released by the government because they didn't protect it. So, does the Sunshine Act require redaction of a name? I'm not sure. I think that could be an issue at a later case when that becomes an issue. Was Director Birn trying to protect a whistleblower's name? I don't know. He said that now that he's been hit with this $1,000 fine. But let's be clear what the actual documents are. The documents are payment records. Those need to be disclosed. If the question is, does the whistleblower get named? I'm not sure. I don't think that's relevant for this case because they weren't trying to protect him because they didn't alert the trial court to where his name was. They didn't alert this court to where his name was. The person that alerted this court, and the only court that knows where the name was, is this court because Mr. Ryan alerted this court to that name, just in full disclosure. So
I'm still wrestling with the idea of the exemption in D. The government says D doesn't apply. And you know, D talks about it at the preface part of it, and then it has the exception to the first part of D is information required from a taxpayer in collection with the taxes that is received in confidence, and the disclosure of information to other persons would result in an unfair competitive advantage to the person supplying the information, except that total amounts of money owed to or owed by a person and penalties levied against and owed by a person is public information and not exempt from disclosure. Is that proviso, that last section, intended to qualify just the initial part dealing with taxpayers and the collection of taxes, as opposed to, you know, someone in a whistleblower capacity, or you have B also that deals with the confidential information that's there, and then you also have I that has confidential records expressly protected by the law.
So I think that the exemptions from disclosure are very narrow. And the idea behind the Sunshine Act is push all documents out, get them out. Do not err on the side of withholding, err on the side of production. And so
but isn't that what I mean, as the government points out, that might just where everybody will disclose everything, even there's a reason to not, for fear that they'll be punished if their reasoning is defective.
Right. And
that doesn't seem like a good policy either.
Well, I would say this, Your Honor, and in cases where there are close calls, that might be an issue. Like, so for example, in this court, in the AB Wanpad Airport case, looked at a situation where the government had, they weren't public records, but they were open meetings and they were attorney-client confidential statements. And there is a requirement in the law that the agency has to go back every 6 months and certify that those things are attorney-client, and the airport failed to do that. And someone was trying to get a hold of their attorney-client privilege, and this court rightfully found that that's not something that can happen. Those shouldn't be produced. Those have to be protected. And so there are going to be fights sometime, especially over attorney-client fights, attorney-client privilege, test books, things like that don't go out, but they need to be itemized. The exception needs to be put down in writing of why that is. If Director Birn had followed the law and responded and didn't produce any documents and still produced, well, I'm withholding these documents based on the same kind of nebulous things he's argued here, which is the Guam's Whistleblower Act and an IRS regulation that didn't originally let the trial court know which regulation that was. Even if he had done that, he'd still be in violation of the statute. Those regulations do not cover these documents. They don't protect the documents themselves, don't protect the things he says he's trying to protect.
Again, I go back to my point. Isn't this case not about what is the correct interpretation, but whether or not there is some justification for taking the action?
And in this case, I would say no. And justification, and this really is part of my third point, which is what the government and what Director Birn is actually seeking is a definition for justification in one part of the statute, and then a different term for justification. He wants to take justification out and say good faith. And so in this case, there was absolutely no, even if we use Director Birn's preferred standard, good faith or bad faith, which is not part of the statute. It's justification. Do you have a legal reason to do what you did? And in here, there's no legal reason to withhold documents. There's no legal reason to ignore the request. That's arbitrary and capricious in every other jurisdiction, or willful, and ends up with punitive damages in those jurisdictions. But even if he had put together I'm not going to do it because of these sections, that's not a justification. And the problem with what the government's asking for is it becomes very difficult to tell what the difference is between, if the way the statute reads right now is if the government bureaucrat is justified, the government keeps the documents. If it's not justified, the documents get turned over. What they're asking for is then to break this duality or this dichotomy up. And if the court makes a first step determination, well, you had to turn the documents over. Okay, the documents get turned over. All right, but you were justified in withholding them. The next step, and I don't want to bring out a parade of horribles, but I will, is the Office of the Attorney General then arguing, but should we really does the government have to pay attorney's fees on the fact that these were good faith arguments?
But it's
and did you really prevail? Did you really prevail?
It's a different standard. If the court orders the disclosure of the documents, I think you have prevailed.
It's only a different standard if the court rewrites the statute and puts in this new definition of justification. Because under the statute as it's currently drafted, if the documents, it's a dual choice. What was the government justified in withholding the documents? They weren't justified. It's attorney's fees and fines. Now, but Part D of it says the court awards costs and attorney's fees should the plaintiff prevail after the initial filing of the complaint. Sure. So if the disclosure of the documents were justified, and so it would seem that you got them. It would seem. And that you would be a prevailing party. You could be a prevailing party, but if the I don't see that finding that the director had a belief, a good faith belief that the document should be withheld, but he was wrong, doesn't make you the prevailing party. Only if the court makes it clear. Because as soon as the court starts to play with this justification, because it is a two-step process right now. It's not as if the trial court erred when it did this two-step process. It imposed what requires. You think the reading of justification because there's two separate provisions, right? The 50 have to be the same. I think that's statutory interpretation, Your Honor. In the same way, and Your Honor asked me if 10108D, if it only applies to taxpayers, because it uses the term taxpayer, and then in the disjunctive part uses the term person. Well, and this is a similar argument. If it says taxpayer in one section and person in the other, the idea that the legislature meant taxpayer, twice, even though it used two different terms, I don't think is an appropriate statutory interpretation. In the same way, if they use the term justification throughout the statute, it doesn't mean a different, it doesn't mean something different.
In my mind,
section.
Mr. Hughesman, you seem to be equating justification for what is the correct interpretation of an ambiguous statute. And in my mind, there is a suggestion that justification can also mean, is there a reasonable basis for the action taken? May have not been the correct basis, but was there a reasonable basis, and that may have formed the justification for the action taken? And I think there is a distinction.
There can, well, candidly, I think if an individual can be justified and wrong, I think that's possible. Is that possible under the current statute, the way it was drafted? I'm not sure. I don't think so.
Well, what about the tension, as CJ Torres has pointed out, between 10108D and 37104 incorporating 37103? 37104 indicates that any award to a whistleblower is exempt from disclosure under the Sunshine Act, whereas 10108D says, well, not the amounts paid to or by the individual. So, you know, there's tension there.
Oh, I don't disagree that there's tension. But
so if a layperson reading those provisions and seemingly are in conflict, you're still saying that it's very clear in terms of what the obligation is in terms of providing what document was requested?
well, in this case, it's very clear. In a hypothetical, maybe not as much. So
why is it clear in this case?
well, it's clear in this case because like I said, the subpoenas do not name the whistleblower and do not name the amounts the whistleblower received. And they should have been produced.
But the subpoena doesn't contain the information, and so what relevance does that have in terms of what is it that you're requesting?
It relates to a request, and that's what I asked for. And the reason it helps, it doesn't matter why it helps Mr. Ryan. Mr. Ryan is entitled to the document, and it's, with respect, it's not the government's business why he wants those documents. If he wants them just to have just to maintain his sovereignty over the bureaucracy, that's his business.
Yeah, but you said you were asking, when you clarified, when you were asked, what is it that you're requesting, and the response to the clarification letter of Mr. Birn, you said you wanted amounts paid to whistleblowers in 2009 and 2010.
Mm-hmm.
And so if the response of the documents or subpoena is not responsive to that, what is the harm to your client that was not provided?
But it is responsive because the original request, which is what is being honored, they don't understand the original request, or they claim they don't understand the original request, but the original request is for documents related to those payments.
No, what about your amended request, your clarifying request? Is it related to that?
Well, I don't think that the clarification supersedes the original request. The clarification is guidance to the department to produce all records that were asked for. Because if we allow the bureaucracy to start playing word games, and I'm not sure, and I don't know, then you get to a situation where, again, the intent of the law is subverted. The law is the way it is, not to.
But I don't see what was subverted. The documents were ordered and they were turned over. Your attorney's fees, your client's attorney's fees and costs were paid for. And what is at issue in here is, was there a reasonable basis for Mr. Birn? Now, I'm not sympathetic to Mr. Birn, who did not respond in the 2-week time period, but was there a reasonable basis for him deciding not to provide the documents based on the sections of the various statutes, the Whistleblower Act and the Sunshine Act?
And I would say there isn't, Your Honor. And the reason it isn't, and I know the Honor doesn't think is pressing on the subpoenas, and it's not just the subpoenas, but it's also the other documents, the internal memos from the Department of Revenue and Taxation to ask for payment, right? Even those, if once DRT originates that document, and if a government agent wants to be extremely careful and wants to black out the amount, if that's what we're talking about, okay, then black out the amount, and then the court in a future case will have a decision about whether or not those exemptions apply. But in this case, the documents that Reventax generated that asked for a payment to itself do not name the whistleblower, do not name anything the information the whistleblower said. And if what we're worried about now is the payment amount, which I don't think is in any of the briefing, but if that's what we're worried about, the payment amount, then that should have been redacted and produced. Something should have been redacted and produced. Nothing was even responded to. And so what I would urge the court is it does not need to come up with a standard on how these different sections interplay with each other, because they don't in this case. And to prejudge it.
The redaction issue deals when there's a partial exemption. If there's a belief that there's a total exemption of everything that's required, then not even redaction would satisfy that, right?
Sure, but I don't believe any of the documents here required a full, and I don't think it's the government's position. Certainly haven't argued it that these documents required full redaction. So most of these documents should have been produced, even if we were worried about the money, the amount, because how the statute interplays, that wasn't, at best, it's an afterthought at this appeal. It certainly wasn't an issue at the trial court. And so if the court wants to figure out what the interplay with these restrictions are, or these exemptions and how they play, I would urge the court to withhold making that decision until it has an actual case or controversy about how those interactions apply. Because you don't necessarily, that's the whole point of a case or controversy. You don't necessarily, you can't think of every permutation. You decide the case in front of you, and the case in front of you, none of these things are at play because they weren't identified and they weren't used.
Okay,
I think I'm over.
You're 5 minutes over.
Yeah, so I just want to say that Director Birn was not justified to ignore any of these things. We're asking that the court affirm the trial court's judgment and award attorney's fees to enforce this appeal. Thank you very much.
The trial court didn't really examine why he was not justified though, right?
No, and the reason because
it made the decision it was disclosable and therefore he was not justified.
Sure, but Director Birn also, at his order to show cause why he shouldn't be held in contempt for failing to follow the Sunshine Act request, complained that he wasn't getting due process, instead of explaining to the judge exactly why these documents needed to be withheld. And instead of explaining exactly why they needed to be withheld, he explained that, well, I'll just give you all the documents and you make the decision, judge. Well, that's not the judge's decision. And once you provide those documents to the judge under this statute, you risk the penalties that go along with submitting those to the judge, to the court.
Right.
Thank you, Your Honors.
Thank you, Mr. Tennyson.
Thank you. Was able to give a little more consideration to Justice Carbolito's question regarding the response or lack of a response, how to deal with that, how to view that, look at that. And if we look at the statute providing the levy of fines, it says, you know, if the court, well, it doesn't say the court, rather just says if the director's decision is not justified under the law, they shall, you know, to disclose, they shall be fined $1,000. Doesn't say in there anything about failure to participate in the process or anything like that. That said, there is a remedy for that. So in this case, Director Birn gets the first letter, asks for more information, second letter, gets more information, doesn't respond. Doesn't fulfill the requirements of the statutes, doesn't comply with the Sunshine Act, becomes liable for a Sunshine Act claim against him in the DOA. Petitioner takes that action, files a lawsuit, Superior Court seeking relief, seeking remedy, prevails, gets attorney's fees and costs. And as a result of that failure to respond, is made whole and having to go through the extra steps, get its attorney's fees, get its disclosure. When we're looking at the fine itself, we're looking at, was there a justification for why they didn't do that? It ideally would have set that forth in the response, said, hey, exemption applies, here's why we're not. But petitioner disagrees, they still take that lawsuit, it still gets hashed out. If they prevail, they still get the attorney's fees and costs. Now, I don't think looking at justification, well, one, I don't think this is just a semantic twisting of words. Justification means something. It's justification at law through facts, reasonable basis. I don't think the attorney's fees are really implicated here. The statute provides prevailing party gets its attorney's fees. You prevail on the substance of your complaint. Initial primary substance of that complaint is disclosure. Now, where there might be a deviation is, let's say, petitioner takes them 10 hours to get the documents and then they spend, for some reason, another 50 really going after trying to show that a fine should issue against the director and they do not prevail on that. At that point, would the trial court be looking at, well, you prevailed on the disclosure part, but you didn't prevail on this additional punitive statutory fine, and therefore I'm going to reasonably award attorney's fees for what was germane, what you did prevail on. But I don't really foresee a petitioner wanting to spend that level of resources on pursuing a punitive $1,000 fine that they're not going to get anything from other than just advocating on behalf of the Guam Ethics Fund, which if they want to, that'd be a great civic service. But I don't think the statute contemplates that. Now we're looking at the trial court, and the trial court said, well, am I going to have to ferret this out? I don't think it was just a matter of giving the trial court the documents and saying, well, here you go, judge, have fun. It was limited number of pages. I don't think there's more than 30 pages. I don't remember the exact amount, but it wasn't a lot of document. And even Director Birn's counsel was confused a little bit about how this should all be applied. We've discussed already 37104 and 37103 discuss exemption from disclosure. We've discussed 5 GCA 10108D too. In my opinion, I read that and it says taxpayer. I think it applies to taxpayer monies, taxpayer information, social security numbers, addresses, phone numbers, relations, familial stuff, and everything that would be on a kind of a tax form. However, it accepts monies and penalties, penalties owed as to taxes. The example was brought out, let's say, there's a contract for widgets with the government and those monies should be disclosed. Well, I don't think those would be disclosed under 10108D. Those would just be disclosed because there's no other exemption. I mean, if we look at the procurement law, there's a standard that everything is disclosed under procurement law unless and this ties into 10108D, unless it provides some kind of a commercial advantage, a trade secret, or something that should be kept proprietary, that shouldn't be disclosed. Otherwise, it's all open and disclosable. There's no exception for it under the Sunshine Act. No exception, it gets disclosed. The exception we have under D is taxpayer stuff, not the monies themselves. And the whistleblower monies, that's not a tax payment. Now, part of that might be taxable income, and that part, as we argue in our reply brief, would be disclosable under this subsection D, but the full whistleblower payment is not a tax amount. It's a calculated reward based on the amount of taxes they were able to collect, but it itself is not a reflection of a tax liability to the person being rewarded. And additionally, if we look at 10108 subsection I, which basically states that any other provision at law is not abrogated by this act. So that means if we're looking at 37104 and 37103, we read subsection I to say that notwithstanding what subsection D says, or anything else in the Sunshine Act, this is not abrogating the function of 37103 and 104. So we can interpret D to say, yes, it does apply to the monies, but not as to 37103 and 104, because it's expressly exempted under subsection I. I think the real issue here, and we've said it in Director Burnson has an opening brief, and the reason why we didn't appeal from the determination below as to disclosure is a couple different factors. One is disclosure has been done already. You can't really unring that bell, return the stuff. It's already been disclosed. In reviewing and doing research, the Whistleblower Act is involved. It wasn't cited that much in the trial court. They really looked at the IRC and how it's incorporated under the Organic Act and some other stuff. And I dug down that avenue and I looked through it. And the IRC provisions seem to be, they make extra effort to protect this stuff. However, sometimes public interest requires that disclosure be had, and the trial court can make that determination. The Sunshine Act isn't it's not this, you're beholden to follow these rules and thou shalt not disclose anything that's it's subject to an exception. The government can disclose anything it wants. There's just some things that there's good policy not to disclose them. There's been discussion about, well, the whistleblower in this case is deceased. I don't know if DOA would have known that or would have gone through that analysis or figured out, well, this person's dead or deceased and gone through that balancing act. I think they would have just looked at what they were told. And when counsel for DOA said they were told many years ago, these are subject to not being disclosed, to my mind, that is the result of the 2018 adoption of the Whistleblower Act saying these are not subject to disclosure. I don't think it was DRT saying, hey, don't give them anything relative to this case. I think it was a statement of, hey, these are protected under the statutes, don't disclose whistleblower stuff. That said, the trial court can still look at it, make public policy determinations. They can do that. IRC does it, federal court, they do it. And decide if it should be disclosed or not. I think the trial court looked at this and said there may be public policy interests. Now, that raises an interesting question about attorney's fees and other things, but the statute just says prevailing party. You bring it, you win, you get your attorney's fees. So we didn't really want to go down that road. There's a lot of issues here. Really giving the documents to the trial court, they weren't just saying, hey, court, dig through it, find it. Figure it out yourself. They provided their concerns. They stated what the issues were. And the statutes here there's a lot of interplay between this. I think if we're being very hard-nosed and precise, an answer can be arrived at that's in harmony and all the statutes are taken into consideration. But is a layperson going to do that? Even to a lesser extent, an attorney within the short period of time from a request to disclosure, is that something they're going to dig into and figure out? And for that reason, I think there should be some deference, and the trial court should have some ability to look at justification as to levying of fines. It's not good public policy to just have strict liability. And these are outlier cases. I think a lot of this stuff is pretty clear, cut and dry. You didn't disclose. Why didn't you disclose it? You weren't justified. But when we get into interpretation of law, and these issues like the Whistleblower Act from 2018, it's fairly new. There's not a lot of policy on this, not any case law on it on this issue I've seen. And that all gets informed going forward. A case gets adopted here, other issues come up, case law is adopted, that informs the policy going forward, that informs notice. People can conform their actions based on that notice. And then if we get here again, well, there's a case on this, why didn't you follow this? That's bad faith. You didn't get proper counsel. You didn't get proper guidance. That's all I have. Thank you.
Thank you, Mr. Tennyson. Thank you, Mr. Huseman. The court will take the matter under advisement. We will issue a written opinion and will now stand adjourned.
All rise.